This is Allyson Brupbacher. Thank you for taking the time to learn more about the mediation process. You're here at mediation because you have to be here, but it's for a good reason. So, one of the big reasons that mediation is so successful is because you and the other party get to be a part of the process versus it happening to you. So, rather than the court getting to tell you how things are going to be, you and the other party get to make those decisions today. The other reason is that your judge is limited on what they are able to do. So your judge has to follow the family code, and that means either one person has this, it's either mom, dad, or yes or no. Today, we can get really creative and we can think outside of the box, and we're not limited by our family code as to what we can do. We can actually tailor it to your family and your life versus what the rest of the state of Texas has to do when they go in front of a judge, which is a little bit more of a rubber stamp. So the way I look at mediation is there are three things that can happen here today. The first is we reach an agreement. I'm going to be typing up all day long, making sure that whatever it is that we talk about is put down to writing. You'll have a chance to look at it, touch it, feel it, make sure it says what you want it to say. But whatever we sign off on, whether it be an entire agreement or a partial agreement, that part is as if it's written in stone. So that means you can't change your mind later on today or tonight or tomorrow. You can call your lawyer up and say, I changed my mind, but they can't do anything for you. It's really that much written in stone. The second thing that can happen here today is that we may get to a point where we need either some more time because our time is up. We need some more information. We need to make some phone calls. Something is keeping us from signing on that dotted line. So we have the ability to press pause on our mediation and come back once we get that information, once we have a little bit more time, whatever it is that is our obstacle, and we can come back and do that. That's what we call a recess. The third thing, though, that can happen here today is that even if I had all the time in the world and all the information in the world, sometimes we just hit a roadblock that we can't get past. That's what we call an impasse. I just ask that, one of my big rules about mediation is that I just ask that I be the one to call the impasse. So I may come in and make an offer and you say, forget it, Allyson, I'll take my chances in front of the judge. You always have the right to say that, most certainly always have the right to do that. I just ask that you commit to the process like I'm committing to the process for you. So until I think I can't do anything else, until I pulled out all of my magic tricks out of my magic hat and I've tried everything that I know, then I will call that impasse. Please understand that I don't mean to keep you hostage. I get paid the exact same amount whether or not we use all of our time up or we only use up a small bit of our time. So I'm not going to waste your time if it's not going forward, but I'm also committed to the process, and so that means staying as far as we can into it until there really is just nowhere else for us to go. Okay? So other important things about mediation are everything here is confidential. Our judge will never know what we talk about. All our judge will ever know is if we reach an agreement and what are the terms. So if for some reason we cannot settle everything today, it will stay here in mediation. To that tune, there are some things that we talk about in each room that may also be confidential. I am completely bound by that confidentiality. I'm going to assume everything is okay for me to talk about in the other room unless you tell me otherwise. So you and your lawyer will be able to let me know if there's something that I can't repeat, and I'll make sure to ask that specifically in certain circumstances as well, is there anything that we talked about that I can't repeat, to make sure that we're always on the same page about that. And even if the other side asks me point blank, then I'm not able to reveal that without permission from you if that's the case. Even though there is that confidentiality in each room, if at any point you want to talk to your lawyer without me present, you just need to let me know. I've been doing this for a long time. I have thick skin. It's not going to bother me. I want you to feel like you are in the driver's seat and you are in control of this mediation. So if that is the case, please just let me know and I'll give you all the time that you need in order to do that. I'll be productive while you are talking and making sure that this is whatever it is that you want to do. Other important things about mediation are today is not the day for us to prove our case. So I don't get to weigh in. That's what your judge does for you. So your judge gets to be the truth police and make determinations about who is telling the truth, who is maybe not telling the truth, and the weight of the evidence. That is not for me to do. Today is really about me being able to brainstorm with you about some possibilities and some options, talking about things that are important to you and that you think we need to address, and for letting me be able to come up with some options for that and some solutions, along with being able to put it in the right wording so that it can be enforceable if it's not followed somewhere down the road. So today is not the need for having to prove things, bringing evidence, showing me proof of whatever it is, because I don't get to weigh in. I'm going to believe everything that is said in each room. And so the way I describe that is you and I can be outside and see a car accident. And when we're reporting that to the police, you may be telling the police you saw A, B, and C, and I could be telling the police I saw X, Y, and Z. It does not mean that I'm more of a truth teller than you or you're more of a truth teller than me. It just means we have different perspectives. And so that's the way I approach mediation, is that in each room there may be different stories or versions of what was going on, but I don't weigh in. I just listen to what's important and what is being said, and then come up with a way to try to solve that problem and help us come up with a solution that will get us where we need to be. All right. So lastly is really just about me and a little bit about my background, which is that I've been doing this for almost 30 years now, practicing family law. I've been board certified for almost 25 years now. And for a period of time, I was the only board certified family law attorney in all of Harris County who only did mediations and amicus work, which is representing kids and some offshoots of that. Since COVID, I got a little bored, so now I still have some cases where I represent people who can sign their own name, but I still limit about 90 to 95% of my practice is mediations and amicus work. So what I hope I can do for you today is use that information that I've been using for quite some time now to help come up with a solution for you, to be creative with you, and then also to talk about some options about if we can't get this done and we have to go to court, what are the risks? And I'm only going to talk to you about things that I've seen with my own eyes and heard with my own ears, because I'm not going to ever guess what a judge can do on any given day, but we can do some risk assessment. So hopefully what we do here in mediation is something that is better than going to court and rolling the dice and just taking a risk.